Okay, this is Kathy Hanville with Anxiety Free Solutions for a Social Media World, Legal and Ethical Issues for Therapists. And in this section, we were going to do an introduction to HIPAA. And this is I am not a lawyer warning, I'm a therapist just like you, so none of what I say should be construed as legal advice. HIPAA's been around for quite a while and it can be a little scary for many of us. It is considered best practice to follow HIPAA rules even if you are not a covered entity. It originally passed in the late 90s and it added a few things in 2004 and again in 2009, and final regulations went into effect in 2013. So there's a lot of regulations to review. The bad news is you're probably not fully compliant, but the good news is you can get there pretty easily. And the nuts and bolts section of this training will help you with that. The first aspect of HIPAA is the privacy rule. There are 6 elements: covered entity, uses and disclosures, research, individual rights, administrative requirements, and compliance and enforcement. And I'm going to focus on the areas that are most applicable to a therapist in private practice. First issue is whether you're a covered entity or not. You are going to be a healthcare provider based on that definition, and a business associate is somebody that you're working with that will have access to your client's protected health information. So that could be a service such as Simple Practice, or it could be a person such as a biller. And covered entities are healthcare providers who transmit any health information electronically or in connection with certain transactions. So, checking insurance, doing billing online, things like that will make you a covered entity. These are the list of transactions that trigger you to be a covered entity. So claims, any remittance advice you get online, coordination of benefits, healthcare claim status. So if you're doing anything with an insurance company online, you are definitely a covered entity. Enrollment or disenrollment in a health plan, eligibility, premium payments, referral, certification, and authorization. Basically, if you're using the internet for your practice, you are going to be a covered entity. If you're not a covered entity, can you turn off this video? No, you really shouldn't, because these are considered best practice rules. So protected health information, which is going to be known as PHI, is defined as individually identifiable health information that includes demographic, related to physical or mental health, or the provision of payment for healthcare. And a covered entity under the HIPAA rules cannot release PHI except as permitted by the privacy rule. So HIPAA requirements are for all medical providers, and there are some allowable reasons for all medical providers that healthcare information can be released, but they might conflict with our ethical standards. So it's important to weigh both. You have to be thinking about both of our ethical and other standards as therapists and what the HIPAA rules are. What is PHI? PHI is almost anything, like names, nicknames, address, dates, phone numbers, fax numbers, social security numbers, email addresses, medical record number, any other account number, vehicle information, which is interesting, but anything like that. So that is protected health information. Oops, there's even some more. But it's anything that can identify the patient as give them help show their actual identity. When can you release information under the HIPAA rules? They make it simple. TPO, treatment, payment, and healthcare operations. Operations being the O. However, we are supposed to follow the strictest guidelines. So when you're looking at HIPAA, you're looking at state law, and you're looking at our code of ethics. So again, as I just said, Just because HIPAA says you can release something doesn't mean it's okay under state law or confidentiality and code of ethics. I do recommend you get a release of information that's specific to protected health information. And that can kind of cover any of these things. And what does your PHI release need to include? Description of the information that will be used disclosed, the purpose for which the information will be disclosed, the name of the person or entity to whom the information will be disclosed, an expiration date, so this is something that's not always on there. Usually you should do them every year. A signature and date that the authorization is signed. The client also needs to be told that they can revoke the authorization, so that needs to be on the authorization. If there's any exceptions to that, how that they would revoke it. And that we're not allowed to condition treatment, payment, enrollment, or eligibility for benefits on whether the individual signs the authorization or not. So this is all information you need for your PHI release. There is a minimum necessity requirement so that when we are releasing information, we must make reasonable efforts to limit or the use or disclosure of. So if you're requested for information, you are required to give out the minimum necessary to meet the goal. The privacy rule gives your clients a very clear right to be informed of the privacy practices of their health plan and their healthcare providers. And each of your clients should be offered a copy of your privacy policies, and that needs to be documented. I have that in my informed consent. I have the paperwork is available on my website, and they are all offered it, and they sign that they were offered it. Your notice must be also in plain language, and it needs to have some specific items in it. So your privacy policy needs to include how you may use or disclose protected health information, what the client's rights are in regards to the information, and how they can exercise those rights, including how to make a complaint, a statement of your legal duties in regards to the information, a statement on who to contact for more information about your policies. That's normally going to be you in a single, a sole proprietor practice. The notice must include an effective date of the notice, an expiration date that relates to the uses of disclosures, a statement regarding affected individuals' right to be notified in a breach. And if you keep psychotherapy notes, you must have a statement that says the release of psychotherapy notes requires a separate authorization. If you don't keep such notes, say that in your privacy policy. If you use PHI for marketing or sell it, which isn't applicable to us, there's some other rules. And you must include a statement that the clients can request a restriction of disclosure of PHI to health plans if the services are paid for out of pocket and in full. So if somebody's private paying, they can request that you not disclose PHI to health plans. Where do you need to have your notice? So it has to be available to anybody who requests it. Clients must be offered one at your first meeting. It must be on your website, and it must be posted at any service location in a place that's accessible to clients and they could reasonably expect to find information. Clients have a very clear right to obtain a copy of their protected health information. Psychotherapy notes are accepted from this. If you do deny the request, you can do that if you believe it will harm a client, but they have the right to ask for a second opinion by a licensed healthcare provider. If you do deny access, you must provide a denial in writing no later than 30 days. And the denial must be in plain language, include the basis of the reason, their rights to have it reviewed, and how they may submit a complaint to yourself or the Health and Human Service Offices for Civil Rights. For record requests, you are permitted to charge a reasonable cost-based fee for copying and postage. You must respond within 30 days, but are encouraged to respond as soon as possible to these requests. You can offer a treatment summary, And if they accept it, that's okay, but if they don't accept it, you must give them their full records. If you keep electronic health records, the client has the right to get them in electronic format. So this is just really important because I think a lot of people, like a lot of therapists, often refuse to give clients their files, and under HIPAA, you don't really have standing for this unless you can seriously document that it would be dangerous to the client to receive them. And this is the feelings that might be coming up when a client requests the records. I understand it can be really stressful for us to have to do that, but it's also a matter of us, having the knowledge that any client could read the records at any time and writing our records according to that. So your grounds to deny a protected health information request from a client that are not reviewable means they can't appeal it. Are psychotherapy notes, an inmate, a research study, a Privacy Act protected record. This might be like a federal agency. And or the information was obtained by somebody else other than a healthcare provider. The reviewable, so the reasons you can deny PHI requests, but a client can appeal it, is if it's reasonably likely to endanger the life or physical safety of the individual or another person. It does not extend to concerns about psychological or emotional harm. The access requested is reasonably likely to cause substantial harm to a person. And the provision of access to a personal representative is reasonably likely to cause substantial harm. Psychotherapy notes, again, are protected from these releases, but they could still be subpoenaed, so that's a different issue. This is, and I'm going to let you read this, I'm not going to read this to you, the definition of psychotherapy notes, and they must be kept separate from the file. If the client reviews the records and they have things that they're concerned about, they have the right to request that you amend anything, and you are required to document that request and whether you are granting it or not, and all responses need to be made in writing. They cannot require deletions, but they can request you add an amendment to the record. The clients have a right to accounting of disclosure, so if they ask you, they can get a written list of everybody that their information has been released to. So you need to be documenting that in a way in the file that if somebody asks you for that information, you can access it reasonably easily. And this is one of these real cases. So this is an individual requests a copy of her minor son's medical records, and they just gave a summary, and she made a complaint and she won it. So there was another one where there was a charge of $100 for a records review fee as well as an administrative fee, and what the privacy rule says is you can include the cost of copying and postage, and it's a reasonable cost-based fee. So you can't just say, oh, it's going to be $100. You have to say it's 10 cents a copy or something like that. All right. And that is your introduction to HIPAA. Thanks so much for listening.